I even wonder if all along being caught was a part of his plan, because he's been sending messages and trying to get his gospel out there in front of everyone for so long. I just do not see this to be the type of man who then all of a sudden takes a quiet seat and sits through a trial. After a multi-day manhunt, the man authorities now believe responsible for the brazen assassination of a health insurance executive is fighting his extradition back to New York to face murder charges. Plus, Grammy award-winning rapper, producer, and music mogul Jay-Z has been slapped with a lawsuit alleging he assaulted a 13-year-old girl along with embattled fellow rapper Sean Diddy Combs. And the military veteran accused of murdering a volatile, mentally ill man on a New York subway has been acquitted and speaks to the media for the first time. All this and more this week on Courtroom Confidential. Well, folks, as we continue to close in on the end of the year, it has been another wild week in true crime. Let's go ahead and jump right in. The man accused of killing the head of one of the biggest U.S. health insurance companies is fighting being sent to face charges in New York City, where the attack happened. Luigi Mangione is being held without bail in Pennsylvania, where he was arrested at a McDonald's on Monday after a broad search following the December 4th ambush of UnitedHealthcare CEO Brian Thompson. During a hearing Tuesday, Mangione's lawyer said he wouldn't agree to waive his right to an extradition hearing. On Wednesday, New York City Police Commissioner Jessica Tisch told reporters the gun found on Mangione when he was arrested in Pennsylvania matched shell casings found at the shooting scene in Midtown Manhattan, adding that his fingerprints also match prints on a water bottle and protein bar wrapper found near the crime scene. At the time of his arrest, officers recovered a notebook that detailed plans for the shooting where Mangione described going to a conference and killing an executive. Additionally, officers recovered what had been described as a ghost gun that may have been produced with a 3D printer along with a sound suppressor or silencer consistent with the weapon used in the murder. What is happening here? Let's talk about this extradition point for a moment, because I know a lot of people have been talking about this and what does it mean and how is it strategically advantageous to the defendant. Let me just start off by saying that extradition is kind of a relic from a time when the states did not exactly see eye to eye on most laws, and oftentimes they were openly hostile towards each other. We no longer live in those times. By and large, aside from a few very rare exceptions, extradition is just a matter of paperwork between states at this point. And in this case, I don't think it's going to be any different. You have the state of Pennsylvania and the state of New York, both governors cooperating with each other to reach the same end. No one's going to argue over whether or not he should be kept in Pennsylvania. Now, just because it's simple and just because it likely has a very predetermined end does not necessarily mean it will happen quickly. Because this is something that goes back to constitutional law, it is something that may take a little bit of time, but end of the day, it's not going to change anything for Mr. Mangione. Now, why is he doing this? I've heard people, commentators saying, oh, it's a good strategic move to buy him time. I'm sorry, I just don't buy it. He's going to have plenty of time. As soon as he gets to New York, they're not going to set this for trial. I doubt, unless he wants to. But if he wants the time and says, I need time to review the evidence against me, this thing is going to get pushed out for a year at least. He controls the clock. So this isn't about, it's a delay tactic in order to give him a strategic time advantage. Quite honestly, it appears a little amateurish. It appears just obstruction for the sake of obstruction. But you know what? It's his right. If he wants to do it, go ahead and do it. It's just prolonging the inevitable. Really, the bigger items that the defense should be worried about is how are they going to defend this case? The more we hear about this, the more I believe this becomes a tremendously powerful circumstantial case for the prosecution, along with some direct evidence, by the way. That videotape, seeing that individual, though he cannot be positively identified there, that is still direct evidence of what took place. His own statements and his own words recorded in these letters or manifesto, whatever you want to call it. It's amazing to me that anytime a person commits an act of atrocity, we call their writings now a manifesto. But this person's manifesto can be direct evidence, considered direct evidence of his statements and his state of mind and what he was thinking and what he's perhaps even confessing to. And that's the other thing. In all of this, there may be arguably, and I think reasonably characterized as such, confessions that he was involved in all of this. So what do you do with a case like this if you're the defense? Well, I think you begin to understand his motives. We've heard a little bit about that. He had obviously problems with the healthcare industry, insurance companies in particular. It sounds like he was dealing with chronic back pain. It sounds like he had had a surgery. This may have caused him mental health issues. This may have caused him to use both prescription and non-prescription drugs that may have contributed to his overall mental health problems. If it weren't for Mr. Mangione, and remember that point for a moment, if it were not for him and it were simply up to a defense attorney, I would say they're going to go in for a mental health defense in this case. They're going to argue some sort of diminished capacity, some sort of lack of appreciation for his own conduct because he was suffering from pain, because he was having this mental crisis and breakdown. But what do we know about Mangione? First of all, he's very bright. Graduated valedictorian of his high school, went on to a very good college. He sounds like a very bright young man. And he's a man with a message, writing those words on the bullet casings. Delay, deny, depose. This manifesto that he put together. His conduct since the time of his arrest, these outbursts he's been having with the media. This is a person who has a message and wants that message to be heard. I do not believe that is the type of person who allows their attorney to make some sort of mental health defense argument. I could be wrong, but I think that this ends in a couple of ways. Either he fights this at trial, takes the stand and gets his message out there, or perhaps he even completes his martyrdom and takes a plea as long as he can get his statement made. I even wonder if all along being caught was a part of his plan, because he's been sending messages and trying to get his gospel out there in front of everyone for so long. I just do not see this to be the type of man who then all of a sudden takes a quiet seat and sits through a trial. But what do you guys think? Put on your lawyer hats for a moment and tell me, how would you possibly mount a defense for Luigi Mangione? Please let us know in the comments. A woman who previously sued Sean Diddy Combs alleging she was sexually assaulted at an award show after party in the year 2000 when she was 13 years old amended the lawsuit Sunday to include a new allegation that Jay-Z was also at the party and participated in the sexual assault. The 24-time Grammy award-winning rapper, producer, and music mogul called the allegations, quote, idiotic and heinous in nature in a statement released by Roc Nation, one of his companies. He also revealed that he had anonymously sued the woman's lawyer, Tony Busby, last month, alleging he was trying to blackmail the rapper by threatening to make the assault allegation public if he didn't agree to a legal settlement. Quote, it made me want to expose you for the fraud you are in a very public fashion, Jay-Z's statement read. So no, I will not give you one red penny. The unnamed woman alleges she was hanging around Radio City Music Hall during the 2000 MTV Video Music Awards and was persuaded by a limousine driver into bringing her to a celebrity-studded party at a private residence after the event. She said that while she was in the limousine, she was asked to sign a non-disclosure document. Once at the party, the lawsuit said she took a drink that made her feel woozy and lightheaded and went into a bedroom to lie down. Combs and Jay-Z, whose legal name is Sean Carter, then barged into the room along with another unnamed female celebrity and raped her. The woman said she eventually escaped the room, fled the house, and called for a ride from a nearby gas station. All right, well, what is happening here? The question I get asked most often about this case is, do I believe, or is there a chance that Jay-Z could be charged criminally? My short answer to that is yes, absolutely. But obviously there is a longer explanation to that. There are two obstacles I think that need to be thought about here in getting to the point of deciding whether or not criminal charges can be brought in this case. And I will tell you, we're going to talk about some ugly details here. If you are sensitive to this type of material, please be warned. But there's two hurdles that must be considered before bringing criminal charges. The first is the statute of limitations. Can they actually bring these charges? Well, I don't want to get into all the nuances of New York statute law. I'm not an expert on it, but I will tell you, in my research and from what I've read from other analysts, there is a tolling statute which applies, given the victim's age in this case, that would allow for a change in the law that took place in 2006 to apply to this case if the actions alleged here, the conduct alleged here, is considered first-degree rape. So the statute would survive and charges could be brought if this is considered first-degree rape. So we got to talk about what actually took place. This is all according to the allegations made in the civil complaint. According to that complaint, Sean Combs, P. Diddy, grabbed this 13-year-old and said to her, "You are ready to party." Then he threw her against a wall, picked her up, and then threw her on a bed. And then Sean Carter, Jay-Z, held her down while P. Diddy had sex with her. That is rape. While the two others watched, then Jay-Z took his turn. Again, that is, in my view, forcible sexual assault, and we call that rape. And I don't see any other argument for that being first-degree sexual assault in the state of New York. Now, the second hurdle, having survived the statute of limitations, having now answered the question of can you bring charges, is do you have the evidence to bring charges? Because it's just not something about one person's uncorroborated allegations. You have to have the evidence to back it up, especially in the case of this seriousness and magnitude, and especially dealing with the defendant that you are dealing with. So can they prove it? First of all, I'm going to make some assumptions. I'm going to assume that they don't have any DNA some 20 years later. I'm going to assume that no examination was done at that time. I'm going to assume that there was no forensics. So putting aside whatever physical evidence may have existed at some point, what are we left with? Well, perhaps we have video. We know that there's a lot of video of these parties. Perhaps we have photographs that might be able to corroborate some of what the victim is alleged took place. But we're dealing with memories and people who may have been there from 20 years ago, people who may not want to cooperate all that much with police. So what do we really have left that we know about now? We know about this other female celebrity. The complaint says that the victim recognized her immediately. She's described in the complaint as Celebrity B. Everyone in the orbit of Sean Combs, P. Diddy, has fled. He has become so toxic that no one wants to be associated with anything to do with this man. And my guess is if approached by police and identified as a person who may have witnessed a crime and may arguably have participated in a crime, and would they be willing to help out the police and cooperate with their investigation in order to not be on the business end of the federal government or the state government who was ever bringing these charges? Would they be willing to cooperate and tell what they witnessed that evening? I think the answer to that is becoming much stronger towards a yes than it may have before Diddy was arrested. When Diddy got arrested, that changed the world. That was a sea change for the entertainment industry, certainly. For a man that powerful who had been operating as a menace unabashedly for so long, to be taken down, he's got no more friends. There's no one willing to be loyal to him anymore. And if it's something to save their own skin, like the position Celebrity B might be in, I think you might see some cooperation. But what do you guys think? Do you think there is any merit to these allegations? Is this just simply a money grab as it's being described by Jay-Z and his team? Or should Jay-Z be far more worried? Please let us know in the comments. After being acquitted of homicide, the military veteran who choked a volatile, mentally ill man on a New York subway told an interviewer He put himself in a, quote, very vulnerable position, but felt compelled to act. Quote, I'll take 1,000,000 court appearances and people calling me names and people hating me just to keep one of those people from getting hurt or killed, Daniel Penny told Fox News in a clip that aired Tuesday, a day after the verdict. A Manhattan jury cleared Penny of a criminally negligent homicide charge in the death of Jordan Neely. The jury had deadlocked last week on a more serious manslaughter charge, which was dismissed. Penny, who served 4 years in the Marines, put Neely in a chokehold for about 6 minutes after Neely had an outburst that frightened riders on a subway car on May 1st of 2023. According to passengers, Neely had loudly expressed willingness to die, go to jail, even to kill, some said. The former street performer was homeless, had schizophrenia, had synthetic marijuana in his system, and had been convicted of assaulting people at subway stations in the past. Penny chose not to testify at the trial, but the jury heard what he told police shortly after his encounter with Neely, describing Neely as acting like a lunatic. Penny said he put the man in a chokehold in order to prevent him from injuring anyone. Quote, I'm not trying to kill the guy, he told detectives. I'm just trying to de-escalate the situation. What is happening here? Like something I've never really seen, the prosecution in this case, and yes, even the judge, took a real chance. They really rolled the dice to try to save a conviction in this case at any cost, and they lost miserably. They dismissed the far more serious count on Friday. Why was that? Because the jurors were deadlocked and because they couldn't consider the what we refer to as lesser included negligent homicide charge, the less serious charge, the charge exposing Daniel Penny to far less time in prison. The jurors couldn't even get to consideration of that unless they had acquitted him of the more egregious charge. So to solve that problem, the prosecution says, well, we'll just dismiss that more serious charge, the one that they're hung on, in the hopes of securing a conviction on the less serious charge. And the judge went along with it. Why? I think just to get a conviction. And is that the way things should be done? Absolutely not. A prosecutor's job is not simply just to check boxes in the W column. This isn't just about winning. It's about doing the right thing. Now, if you feel that the right thing, that this man is guilty of manslaughter, and you have the facts and evidence to prove that, and that is what you feel is the right thing to do, which, by the way, brought along 14 years in prison, then do that. But you don't then, at the 11th hour, after it's already been submitted to the jury, change your mind and say, you know what, we don't really care anymore. We're willing to take off that more serious charge, remove essentially 11 years of exposure from this man just to secure ourselves a conviction. I don't think that's the way things should be done. What should be done? You take the mistrial and you go back and you try it again. If you feel it's that important, or if you feel like your case is not worth it, you offer something else, you charge something else, but you don't just at the last minute make these types of maneuvers so that you can get yourself a checked box in the win column. Because what lesson did the prosecution learn from that and from the judge going along with that? What precedent does that set? Well, it says, you know what? Go ahead and give it a try. See what sticks. Throw it against the wall, see what sticks. See what you can't get away with a jury. And if that doesn't work, at the very end, just go ahead and remove that charge and see if they'll go for the less serious, perhaps more reasonable charge against this person. I don't like it. I think it's dirty. I don't think it's the way business should be done as a prosecutor. But what do you guys think? Do you agree or disagree with the verdict in this case? That's my question to you. Please let us know in the comments. Before we dive into the other cases making headlines this week, I'm going to ask a very small favor from you, and that is, if you have not already, please take a moment to subscribe to this channel now. We appreciate the response and the support that we get from all of you, and we want to continue to provide you with more and more content every week, and the best way to do that is through your subscriptions. And don't forget to check out Courtroom Confidential as a podcast. Please join our community on all major podcast platforms. Also making headlines, Lori Vallow, the so-called Doomsday Mom, will be allowed to represent herself in court. This news coming just one day after a judge deemed her mentally competent to stand trial. In Arizona, Vallow is accused of conspiring in the fatal shooting of her fourth husband, Charles, and the attempted murder of her niece's ex-husband, Brandon Boudreaux. The shootings of Charles and Brandon happened within months of each other in 2019, with investigators believing the triggerman in Charles's murder to be Vallow's late brother, Alex Cox. According to police, the shootings were motivated by money and a bizarre spiritual belief system. The decision to allow Vallow to represent herself came just one day after doctors agreed during a Rule 11 hearing that Vallow is mentally fit to stand trial. The state did not object to the doctor's findings. When asked by Judge Justin Bareski if she wished to represent herself, Vallow responded, quote, "For the past 5 years that I've been incarcerated, I have taken it upon myself to study case law and criminal rules of procedure in the state of Idaho and Arizona, as well as federally." She continued, "I have real trial experience. I've participated in 3 different full trials from beginning to end." Her trial date has been set for March 31st, 2025. The judge in the Karen Reed case heard statements on Thursday from a medical specialist to determine whether she will allow the physician to testify at a retrial that the wounds on John O'Keefe's arm appeared to have been caused by a large dog. Dr. Marie Russell, who worked as an emergency room physician for 3 decades in California and still consults for the state's medical board, had offered that opinion during the first trial, which ended with a hung jury in July. Prosecutors allege Reed fatally struck O'Keefe, a Boston police officer she had been dating, with her SUV in January of 2022 after dropping him off outside a Canton home following a night of bar hopping. Her lawyers say she was framed and that O'Keefe entered the Canton house, owned at that time by a fellow Boston police officer, where he was fatally beaten in the basement and possibly attacked by the family German Shepherd before his body was planted on the front lawn. On Thursday, prosecutors requested to bar Dr. Russell from retestifying, asserting that she had failed to provide a proper basis for her opinion at the first trial. No ruling has been issued by the judge as of the time of this recording. The retrial is scheduled to begin April 1st. Police investigators have revealed that DNA of missing San Antonio mother Suzanne Simpson was found on a saw owned by her husband. Brad Simpson is charged with his wife's murder, aggravated assault with a deadly weapon causing serious bodily injury, tampering with a corpse, and possession of a prohibited weapon. The indictment accuses Brad Simpson of altering, destroying, and concealing a human corpse on or about October 7th, the day after Suzanne was last seen alive, according to investigators. He's also accused of concealing a reciprocating saw and a fully automatic firearm and possessing an unregistered machine gun, according to the indictment. After roughly 2 months of searching for Suzanne, a grand jury gave prosecutors the all clear to pursue murder charges against her husband. Suzanne's body still remains missing. Simpson is expected back in court on February 12th. A Wisconsin man who faked his own drowning and left his wife and 3 children for Eastern Europe willingly returned to the U.S. after 4 months and was charged Wednesday with obstructing an intense lake search for his body. The criminal complaint charging Ryan Borgwardt with misdemeanor obstruction offers a detailed account of how the 45-year-old pulled off his disappearance and was living in the country of Georgia when he realized he had left too many clues behind. According to court documents, while carrying a small inflatable boat, Borgwardt paddled his kayak out onto Green Lake, where he overturned the kayak and dumped his phone in the lake. He then paddled to shore in the smaller boat, grabbed an electric bike he had stashed near at a boat launch, and rode 70 miles through the night to Madison, Wisconsin. From there, he boarded a bus to Detroit and crossed into Canada, where he boarded a plane. Appearing in court Wednesday, Borgwardt said he planned to represent himself, citing financial hardship. When the judge asked him where his bond should be set, Borgwardt quietly said, "I have $20 in my wallet, so that's what I have." If you care to hear more about the details of this case, we did an episode of our Wednesday night live series talking about this case that we will link in the description below. Two-star luxury real estate brokers and their brother are accused of using their wealth and status to lure, drug, and then sexually assault and rape dozens of women, according to a federal indictment made public on Wednesday. Oren Alexander, his older brother Tal Alexander, and Alon Alexander, Oren's twin, were arrested at homes in and near Miami Beach on Wednesday. The twins also face separate state felony charges of sexual battery connected to 3 separate assaults, according to arrest warrants released on Wednesday. According to the federal indictment, the 3 brothers had conspired in the sex trafficking scheme for at least 14 years. Coordinating with other men, they arranged events and domestic and international trips as bait to recruit, entice, and transport women whom they later raped. U.S. prosecutors say the women who were victimized were often provided drugs, including cocaine, psychedelic mushrooms, and GHB, and the brothers even surreptitiously drugged some of the women's drinks, leaving them physically impaired and unable to fight back or escape from the sexual assaults. A bail hearing is scheduled for Friday, December 13th. Before we jump into what's on the docket for next week, I want to take a moment to thank you all for your support. We really appreciate the love of our growing community, but we want to give a special shout out to Girl Ryan82 for their glowing review on Apple Podcasts, and to our new members Tiffany AXO and Shark Shell for their kind words on YouTube. Keep them coming. We highly appreciate your feedback. On the docket next week, former Colorado dentist James Craig, accused of fatally poisoning his wife in March of 2023, is facing new charges after he allegedly tried to convince a fellow inmate to kill a detective on the case. After these recent charges caused his defense attorneys to withdraw, Craig will now appear on December 16th for a pretrial hearing with new counsel. A preliminary hearing date has been set for 3 of the 5 defendants of the anti-government group called God's Misfits, accused of killing 2 Kansas mothers. The defendants will appear on December 17th to determine if enough evidence exists to have them answer at trial for the murders of Veronica Butler and Jillian Kelly. Jake and Angela Wagner will be back in court on December 17th to be sentenced for their roles in the Piketon massacre, where 8 members of the Roden family were killed in southern Ohio in 2016. The sentencing will take place the day after Bill Wagner's next hearing to set his trial for the murders. Suspected Gilgo Beach serial killer Rex Heuermann will be back in court on December 17th to set a date for his trial. Heuermann has been charged in the deaths of 6 women between 1993 and 2011. The remains of 11 people were discovered around Gilgo Beach during that period, and investigators have said he may be linked to other killings. Richard Allen, the former Indiana drugstore worker who was found guilty of killing teen girls Abigail Williams and Liberty German in 2017, will be back in court on December 20th for sentencing. Allen faces up to 130 years in prison. And finally, the latest episode in our Courtroom Confidential Conversation series will premiere this Monday, December 16th at 5 p.m. Pacific, 8 p.m. Eastern, where we interview Joseph Scott Morgan. So please join us in the live chat. That is it for us this week, folks. I am your host, Josh Ritter. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.